Take off the big pile. Good evening. Welcome to Aldersgate United Methodist Church. We're so glad to see everybody here, and we're also welcome everybody who's viewing online. I'm Carrie Beckenhauer. I'm part of the Lasting Legacy team here at Aldersgate. A couple of housekeeping things before we get started. One is that the restrooms are out the double doors. Left down the hallway, you'll see the water fountain. You'll know you're in the right place. We'd ask you to please make sure your cell phones are silenced. I just did that with mine, so hopefully it won't go off. And you'll also notice that there's an emergency exit on every wall in the sanctuary. Not that we hope that we have to use them, but just in case. This is our 6th presentation in our Life and Legacy Planning series. Our speakers typically talk for 45 minutes or so, and we usually leave a little bit of time at the end for question and answer. We will bring around a wireless mic when we do question and answer. Please use the wireless mic. That allows people at home to hear the question. Larry Ruth is our speaker tonight. Many of you probably know him. Larry grew up near Rising City, I should say. He graduated from Nebraska Wesleyan and then graduated from the University of Nebraska College of Law. After that, he joined the Navy, and he did law work when he was in the Navy during Vietnam. Now, Larry's done only about 1 million other things and has won all kinds of awards and so forth. But I'm going to keep this short, so I'll just say that he retired recently from Ruth Mueller Law Firm. It's now Mueller-Roback. But Larry worked as a lobbyist, and he's helped craft a lot of legislation. Some of it you're probably going to hear about tonight. So please join me in welcoming Larry Ruth.
Thank you, Carrie. I appreciate saying that she's going to keep this short because I feel very comfortable with the idea of shortness. There are some rostrums or lecterns that I've been in front of that I can't see the front row, and so I get on my toes, and it's much nicer to have it this way. I really enjoy being here, and this series has proved to be very beneficial to many of us in the congregation. And what it's combined with, especially a ministry we have here on care and recognizing the need for working for caregivers, it does provide a real fine support for those who have to go through grieving or for caring for folks. And because I've seen some people here who were at the last caregivers meeting earlier this last week, and welcome to all of you. Well, this series focuses on our life and the legacy that we leave after we die. And it's important to know that the word legacy is very powerful in its effect. There's almost nothing you can watch on television anymore that doesn't have an advertisement for your opportunity to leave something as your legacy, whether it's PBS or some kind of environmental cause. Everybody wants to be a part of your legacy. I guess I'm talking about something a little more personal than that legacy of giving, although that's absolutely essential to keep a legacy of giving in mind. But I'm really talking about the way you can handle your health and your resources to have a comfortable way of moving into your retirement or moving through your retirement years. And I think we have to start, unfortunately, with the downer of the evening. And the downer of the evening, I'll get it out of the way right away, is the definition of death. You can't really talk about life and legacy without understanding what death is. I'm on a national group that works on laws for all of the states And we've been working on the definition of death for several years, trying to figure out if we should update the one we have now in our group of laws, which we then take to the states for their adoption. But that's really, really difficult. Very, very difficult concepts to take into consideration. But the important part to remember is that it is a definition, a statutory definition. So either you are or you aren't by the definition. You can't make much argument about whether you've got a spirit or you have something afterwards. Those are very important spiritual questions, but they're not the definition of death. So let's look at that very briefly. A person is dead if they are either, number one, have an irreversible cessation of circular and respiratory functions. Now, what does that mean? They can't breathe and they can't circulate the blood. So if they don't have a heartbeat, that's part of the definition, or they don't have a breath. That's also part of the definition. So that's over here. And then you have something called the number two, or the second half of death, which is they can also be considered death if they have a cessation of all functions of the entire brain, and that is including the brainstem. Now let me just point out, if you look at the next line after the definition, it says source, laws, 1992. 1992, so that's how many years old? We've been going through a lot technologically in the last 20, 25, 30 years. But it's very hard to change the law when we've been going through as much technology as we have in this area. So now we have sustained life. I say life, sustaining of something we might call life with artificial means. Either that's circulation or respiratory function, or some things that we don't know about, but outside of the brain stem and the brain. I had a son that just had open heart surgery about a month or two ago, and part of that was taking his heart and doing a bypass of his heart so they could then cut open the heart and remove a valve and replace it with a new valve, basically. Wow, they'd never thought of that probably when they were coming up with some of the definitions. Certainly, that wasn't something that Doc on Gunsmoke would consider doing. As far as Doc on Gunsmoke, he would say, I don't hear a breath. No, I don't feel a pulse. Matt, he's dead. You know, that's about all it took. That's about all it took for us back in the day. So this definition has been under criticism, and I'm going to say that it's still somewhat functional, but it doesn't give a lot of structure to the way we now have artificial means of respiration, of circulation, and who knows what artificial intelligence and others will do on some of the other functions of the body. It is important to know the part of the body continues to have functions even if the brain is, quote, dead, even if you are so-called brain dead. Some of the functions of changing from adolescence to adulthood in young people who are otherwise completely incapacitated, part of their body will still continue to mature. Now that's sobering, isn't it? It isn't just a function of the brain, there are other things that are coming into play. So, and it's very important because not only is it important for us tonight, but if I'm in a shootout with somebody and I shoot them with a gun and they are then kept alive this way, am I to be charged with murder because of death or to be charged with aggravated assault? Well, that's an extreme example, but the things that we do every day that depend upon knowing when death occurs is very, very important to us. Now, we got that out of the way. I want to look at some of the good things that we have. we have by structure in the legislative law powers of attorney. And how many of you have ever executed a power of attorney? Looks like some have. Basically, it's you as the principal giving to someone else the authority to act on your behalf. That person that you're giving it to is called the agent. There's this old language called power of attorney. I have yet to understand where that came from, but that's the name of it, a power of attorney. And you're giving to someone the authority to act on your behalf. When I was in the Navy, I helped seamen execute literally hundreds of powers of attorney. When they were going out on their trip out to sea, they would always be told by the commanding officer, go make sure your will's up to date and you have the power of attorney to your wife. That was sort of the way that they were told to go see your JAG officer, which I was at that time. This power of attorney typically is a durable power of attorney. Now, who knows what that might be? What does durable mean? Keeps living, right? The power of attorney that is given from me to you goes into effect immediately and then lives on even though I may become incapacitated. The old law used to be that when the principal became incapacitated, then the power of attorney was revoked. That's no longer the case. By statute and by common law, it recognizes that we want durable power of attorneys. Usually, if you do want them for a limited period of time, it's very easy to say that this power of attorney shall be revoked on January 1, 2026, for example. But typically, a power of attorney will go until it is revoked. And that will happen usually by a subsequent power of attorney where you say, I revoke all prior powers of attorney. Now, why is that important to understand that? You don't want a bunch of different instructions floating around with your signature on it to maybe different people to do good things for you. So you want to keep that up to date. Obviously, in selecting a power of an agent for your power of attorney, you want to select someone you trust. And that's oftentimes a relative, doesn't have to be, but it should be someone who takes seriously the notion that he or she is acting on your behalf. And they have to act on your behalf. They have to do the thing that is best for you. That wouldn't mean selling things that have a poor chance of making any money. It would be taking care of your resources, which is generally your property, or some of the other things that a power of attorney can do. So the first type of power of attorney on page 4 is called a general power of attorney. And that's generally to act for someone on your behalf, dealing with property. There are a lot of things that can be. Selling a house, typical. It's on page 5. Selling a house, working with banks and other financial institutions, getting benefits from governmental programs or civil or military service. Those are all things that would fit into this, but a lot of other things would too. A general power of attorney is not intended specifically for a specific thing as much as it is for a general type of matters of your interest. The second type of power of attorney is one giving specific authority, and that's on page 5. Now this is given specific power so that you really think about this one before you make changes. For example, you can create or change a beneficiary designation by a special power of attorney. That's important. I mean, changing the beneficiary on your insurance policy, you better know who's got that authority, and they better know that it's specific for them. Other types of things you can give to them, or you can limit their authority, as on page 6. and you can give instructions, but limit those instructions. For example, may only be done with the National Bank of Commerce. I was speaking with someone here who used to work for NBC. Or limiting it to who they can do it with, or the dates involved. But it can be very easily manipulated to meet your various needs. You can also use that to nominate a conservative or a guardian. Now, the difference between those two, if you want to nominate a conservator is someone who will look after assets that you may have, help you with assets. A guardian is someone who relates to your person, taking care of your needs, those sorts of things. So those are two different kinds of things, people that can be nominated in a power of attorney. I don't want to dwell on this stuff on page 6 and 7, dealing with how you go about executing a power of attorney, because I'm sure you're saying, gee, why did they waste all this paper on this? There are some things here that I too want to emphasize by having it pointed out to you. On page 7, this document must be signed in the presence of a notary. This isn't something you can just take home and on your dresser, which may be encumbered by other things. My wife would say, that's right. That you pick it up and say, oh, I think I'll execute this power of attorney. You got to take it in front of a notary. Or I think this allows, for a notary. Now that's, pardon me?
Can I ask a question?
Yes, sir.
In order to do a power of attorney, does it have to be in front of a notary, or can it be witnesses?
Well, I put down notary. That's what it says on this, so I'm going to go with that. Let me just explain where these powers came from. One of the things our group was to come up with the Uniform Power of Attorney Act, adopted in Nebraska, adopted in Colorado, and many different states. There are slight differences, so each state might have it different as far as having it authenticated, that is, the signature being known as that being your signature. And that would be either in front of a notary or a notary public or a witness. I have a cousin in Denver who does not have any family, except for me, basically, or source of income except from Social Security disability benefits. And the city of Denver could not get her on a program unless she had a power of attorney. It happened to be they needed a power of attorney for end-of-life decisions, but the point is the same. They did not require for me to be present. It's her that had to be present in front of a notary. And so as this unfolded, I said I would do it. And then they authenticated it there in front of a notary. So Colorado law required it in front of a notary. Nebraska law says use a notary. And the important part of these forms is that these are in the statute, but more than that, they're under the Supreme Court. And the Supreme Court has a section preserved for self-help. There are certain things that it wants to make sure that if you do it right. And so they have this in their self-help section. I would recommend doing it in front of a notary if that's what they say they'd like to see. And I think it's probably what the statute says. Okay, let's talk a little bit about what I really think most of you are probably most interested in, at least my experience with the last speakers, is that they were interested more in health care and death preparation than whether you're going to sell a car or sell a house or something. So turning to page 8, I would like to kind of start on the talk of the Nebraska Power of Attorney for health care. Now, once again, this is a form that you can rely upon. It's in statute. And it's also, at the Supreme Court level, they approve of it. So how do you use a power of attorney for your health care and the way that you want to die? Or if you're going to, when you're going to die? This is a little bit different. It's durable, but what it does is, if you'll notice at the bottom of page 8, maybe a second paragraph before, I authorize my attorney, in fact, that's your attorney, for health care appointed by this document to make health care decisions for me when I am determined to be incapable of making my own health care decisions. So this has got a little bit of a twist. It doesn't put a limitation on when it's effective, with the exception of you have to have a doctor saying this person is incapable of making decisions. Not only understanding what the decisions are, but being able to communicate them. So if you're going to use this, and if it looks like it's going to be used, you have to do a little bit of work ahead of time to have the doctor say that the patient is incapable of making their own health care, and we want to authorize this person to stand in his place. And this is really kind of important because, this is a life and death decision, oftentimes. That's why I'd call it for health care and death. And even though it's one that will last probably forever at that point, until the person dies, before it can be exercised by the agent, the person has to be incapable of making that decision or communicating it. In my particular case with my cousin, I was sort of in and out. You know how that goes. You can make a lot of sense, and then sometimes would do something kind of silly. And the folks that she was working with from a medical standpoint recognized that, said that she's incapable of making decisions and communicating them, although she's very bright and extremely nice to talk with and work with. She needed to have someone else make those decisions. Now you don't have to be working with a clean slate, so to speak, because there's plenty of opportunity for that person in the exercise of filling out the power of attorney to tell you what they really think, to tell you what they want, to tell you whether they want to have health care, life-sustaining treatment continued or not, to tell you whether that should include or not hydration, for example, the different things that you can do. But the point is that it has to be carried out only if the patient is in need of assistance. And that's a medical decision. I have that power of attorney with me, and she made a lot of good decisions, in my opinion, for her situation, and she felt very strongly about them, and now I'm going to be feeling very strongly about them, because I'm supposed to follow those directions when I know what they are. That can include instruction. You can have instructions including life-sustaining treatment, what you want to have given to you by way of life-sustaining, such as artificially administered nutrition and hydration, and there are a number of options like that. I don't want to burden you with those right now, but if you'd like to know where you can get an idea of some of those, I can sure help you with that, perhaps after we finish. I will now let you know what I do, what I've done, and I have done powers of attorney for health care for a number of years. The most recent one was in a will that my wife and I executed, wills that we executed, I should say, in 2022. And there is a section on what by will, telling me telling others that we want to give a health care power of attorney to someone. In my case, it would be our oldest son. What can you do with that power of attorney after it's executed? Well, what can our son do is the better question. He can employ, in the middle of page 11, he can employ and discharge healthcare personnel. And we know that that's fairly important. There comes a time sometimes when you just don't think that mom or dad's getting the care they could be getting or should be getting. And that can be for health care of any medical treatment, both of a doctor or a healthcare facility. And here's where you begin to get some of the things you believe, some of your beliefs going into effect. Number 3 is to give, withhold, withdraw, or modify consent to medical treatment. There are some things that the medical community needs a consent before they'll do with you, and that's something the agent will do. But right in the middle it says, my agent's decisions should be guided by taking into account the provisions of this document, and there's some other things where it talks about these provisions. But number 2, any reliable evidence of preferences I may have expressed on the subject, whether before or after the execution of this document. So it encourages the agent to talk with the principal. If you want the agent to really understand what you would do under the circumstances, you should talk with the principal, you should talk with grandma before you can't do that anymore. But get the sense of what he or she would like. Number 3, what my agent believes I would want done in the circumstances if I were able to express myself. In other words, put the agent on the spot. Tell me, Larry, this is my son speaking, tell me, Dad, what would you do in this circumstance? And that would be helpful to him in making a decision on working with giving his opinion. And any information, number 4, any information given to my agent as physicians treating me as to my medical diagnosis and the effects of treatment. This is kind of important, I think. It's good for the agent to know from the doctor involved and other personnel what the medical diagnosis is, what the prognosis is, clearly, in their opinion, and then what the risks and side effects are associated with the treatment. Sounds reasonable to me, that I would like my son to know what the problem is that I have. It may be dementia. Not only dementia, but the prognosis for it may not be too great, or maybe 6, 10 years, 20 years. And what are the effects related or associated with treatment, whatever that might be. Then it says, this is language you will hear again and again. The authority granted specifically includes the authority to withdraw the providing of nutrition and hydration as life support. That's typically one of the things that is withdrawn when you want to withdraw life support. It's hydration and nutrition. That would be typical. If treatment is necessary to prolong and preserve life for the harvest of organs or tissues from my body, then my agent may allow and is encouraged to authorize this treatment. What do I mean by that? There's a natural tension between the organ procurement community, that is the folks who hate this term, but this is the term, harvest organs. There's a tension between them wanting the body to stay alive as long as it can so they can get to the body and do the harvesting. And over here, what you may say is, don't prolong death or prolong life with her. Now, when you think about it, it's an easy decision to make for the person, for the patient. They should say, just like I've said here, what trumps in that particular case is keeping the body going with artificial circulation and respiration, keeping it going long enough to have a good harvesting of the organs. If you don't have that, you have this conflict, and you can see it isn't just lawyers that like conflicts. It's doctors and patients like, and family likes conflicts, because some of the most unseemly and heated arguments can be within a family when there's a discussion over whether there should be organ donation. And that would be an example of one thing you can clear up in a will or another document. I want to say that I authorize relief from pain, and that's pretty normal. And also to authorize organ and tissue transplantation and donation. And I've got a whole section here I'm going to get on at the end on making organ donation registration and having that available as a tool for maybe even a tool for passing your life on to another life. Now talk about a legacy. You know, we think of legacy sometimes as how much money you can give for the building over here or for the fund drive over here. But think of the legacy of giving your life for another life. That's pretty valuable. Now, there's this thing called the Health Care Directive also. You not only have a power of attorney, but you also can have what's called a health care directive. And a health care directive is when you're directing someone to do something. That's different from you have the discretion to do this, or you use your best ideas here. This is a directive. And this is a directive to the medical personnel that are involved. My attorney, and I've got an attorney, my attorney preferred to have both the directive and the other power of attorney, well, the other directions in here in one document. And I think it made sense. But we'll go over these again for you because this is a little bit different. Healthcare directive, once again, it's a different kind of tool that you have. And that, once again, is someone, now it's pontification just a little bit, says, I request, second paragraph, first paragraph, I have strong objections to the administration of medical treatment solely for the purpose of preserving my life. If I'm unable and incompetent to enjoy a further life. That's a pretty strong statement. But I think that's probably a statement that a lot of people would endorse. It's just written in a nice way. And then this is what, in the second paragraph under Healthcare Directive, I request my agent and any person charged with the responsibility for my care to be guided by this expression of my witnesses. If I am physically unable to care for myself without constant help, if I'm mentally incompetent to understand my condition and recognize those about me, and my physical and mental condition cannot be significantly improved by further treatment, then I direct, I'm giving an order here to the medical personnel that no treatment intended solely to prolong my life be applied. That's pretty straight. I think that's what you want to have in the kind of document that I want to draft. Now, that's not to say that you have to do the same thing. You can just about put "not" in front of any of these things if you don't believe in withholding health or life-sustaining treatment. And do the same thing, but do it in reverse. I direct that, even though it might be solely to prolong life, I want my life to go on without medical interference. I mean, you can just see how I manipulated that sentence to say just the opposite. So it doesn't matter of giving a directive that just is got one theory behind it. It can be several different things you can accomplish. And then, yes, sir.
The statement about direct no treatment intended solely to prolong my life be applied. That could be
interpreted by an attorney or someone else to be kind of a vague term.
Well, I suppose you could have a situation where the treatment would be naturally ordered by a doctor, typically for prolonging life, but maybe it's to, I don't know, I've talked to a doctor about that, but there might be a treatment for a non-life sustaining purpose. It says solely, I'm going to say that would be the way you'd interpret it, that if it's only for purposes of sustaining, prolonging your life, then you don't want, then I didn't want that. And my life should be permitted to end without medical interference. That's the way this reads. Then this is important. If such medical treatment has commenced, it is my direction that such medical treatment be withdrawn. So there's two sides to this issue. One is, are you going to have your life sustained? And then you might say yes. 10 days later you say, or your agent says, look, this isn't going anywhere. This is going to have a bad ending, but it may be a long time from now. It's not good that all it's doing is just to prolong life. And I'm going to ask that the treatment be stopped. And that makes sense too, it seems to me. Okay, you can make under state law what's called a declaration relating to use of life-sustaining treatment. So now we're getting very much just right at the issue we're talking about, and that's withholding or withdrawal of life-sustaining treatment. This is going to get interesting, so sit back, because this is going to be what I heard on NPR this morning, partly, when we get there. You can make a declaration governing the withholding, a separate one governing the withholding or withdrawal of life-sustaining treatment. Once again, it uses that kind of language. And it's something that's been in the state statute books since 1992. Here's the kicker. Number 3 on page 14, and this has been here since 1992, says that a healthcare provider who is furnished a copy of this declaration, if he or she doesn't want to do it, they've got to tell about it right then, so that the agent can be assured that when the time comes, the doctor is going to do what they say they're supposed to do, and to put it in the medical record accordingly. Now, make sure I got the right information here. Yeah, I think this is, this goes to what I think was handed out separately. Because this gives, and what I handed out at the top, it says 24L8. And this one says a qualified patient can make decisions and under the rights of the terminally ill, which is also in state statute, says that you have the right to terminate your life. And to require others, when I say terminate your life, you can have the right to order that treatment be terminated in order to end your life. Number 3, life-sustaining treatment shall not be withheld or withdrawn pursuant to this declaration if known to the attending physician that the person is pregnant, as long as it is, and this is some terrible language in my opinion, as long as it is probable that the fetus will develop to the point of live birth with continued application of life-sustaining treatment. Okay, what does that mean? Right now in Georgia, there's a woman by the name of Smith, I believe it is, Adriana Smith, who was having headaches, terrible headaches, went to the doctor, found that she had a number of clots in her brain, and she progressively got worse. And also lost her ability to do anything. And at that point, though, she was 2 months pregnant. And under Georgia law, you can't end the treatment of somebody if the doctor says this person is pregnant and the child, the fetus, it's probable, notice the word probable, I don't know what that means. It's probable the fetus will develop to the point of live birth. Boy, that's a lot of speculation. And it goes just about everywhere, and it's in front of the courts right now in Georgia with continued application of life-sustaining treatment. Now, it's a little bit different situation because in that particular case, the doctor says, I won't do this, I won't terminate it because I'm afraid that I'm violating the anti-abortion statute. The anti-abortion statute in Georgia uses the same idea. You can't have an abortion if it's probable that the fetus will develop to the point of live birth. Well, those are really difficult standards to live by and to practice medicine by. I'm just saying that to tell you and show you that the definition of death and what we have to put into statute is very complicated and very difficult, especially when you begin to put in ethical issues, religious issues. I got a kick out of my conversation with my wife, Pat, today, because I was looking at the different words. I love words. And there is something called quickening. Anybody know what quickening means? A child is quickening when it makes movement that the mother can feel. That's the quickening. That is quickening. So that word has been used sometimes to mean live, alive. So sits at God's right hand and then shall come to judge the quick and the dead. You know, we use some of these words, long time old words, in different ways. But I digress. I get a kick out of trying to understand what point of live birth means, develop, what that means, probable, my goodness, does that mean beyond a reasonable doubt, or does that mean by preponderance of the evidence? Those are two evidentiary standards that we use for different reasons. I don't know what it means, but it's a clash of two very, very sincerely held beliefs. One is that life begins at conception or shortly thereafterwards, and the other one is that fetus at the right of the terminally ill to allow withdrawal, or in this case to have an abortion, should be allowed. I don't know how that's going to come out, but do listen and read the paper about it, because it's one of those ones that is of interest to us as we look at this subject. Okay, I'm going to go ahead a little further. I'm on the NRD, Natural Resources District, and turn those initials around, you have DNR. Do not resuscitate. I have to be careful when I'm talking, I don't use the wrong DNR or NRD. How many of you are familiar with the order to do not resuscitate? Have you ever had to use it? Have you ever had to have it in your family? Not necessarily use it, but the doctor is the one who issues the order to do not resuscitate. Okay, what does that mean? Now, this is page 15 is a document that I got offline. Upper left-hand corner, Emergency Medical Service Oversight Authority. I have no idea what that is, except that it is located at 555 South 70th Street, and it's also South 48th Street. I think that's probably the county in some way, or the state. I have to ask my friends that work in those areas. But this form, I understand, is one that is capable of being used. But I don't think you would do it by yourself. I wouldn't just sit down and say, well, I think I'll order a do not resuscitate. In the first place, you have to have certain things explained to you by the doctor before you do that, before you interfere with orders within the medical community. But what does it say? Page 15. I, your name, have been diagnosed as having a medical illness. I've discussed both the prognosis and the treatment options and request that in the event my cardiopulmonary arrest in the event of my cardiopulmonary arrest, meaning if I have the functions of your heart and or your lungs are arrested and resuscitation is required, that they not be initiated. Now that's supposed to start with the doctor giving the order and then follow down through the chain, as I understand it. We have some nurses on hand. If there's a doctor that orders a DNR, a do not resuscitate, that's supposed to go on the medical record. It's supposed to be in some way recognized then by those that are in that chain of command. I have a real interesting question, and I think I know the answer. I'll ask you a little later. It says, I give, in second paragraph, I give permission for this information to be given to an emergency medical service, I guess that would be the ambulance, mobile health care personnel, folks coming in, physicians, nurses, or other healthcare personnel. That means probably someone employed in a healthcare capacity, as necessary to carry these wishes. I understand that this order is valid until rescinded by either the patient or the durable power of attorney principal, or rather agent. Now, that means that when the situation is such, on the care of grandma, your spouse, or your child even, that you believe the prognosis is such and the treatment options are such that you think the physician should order a do not resuscitate, then that's what should be done. Now, I think the doctor has some authority in that regard, and you wouldn't expect him to agree to that just willy-nilly, so I don't know how that works. But this is something that he or she then puts in the record, and with that, there will be an order to not resuscitate. Now, what does that mean? It means that the patient will not be intubated. We know what that means. There's not intubation of a breathing tube of some kind to maintain respirations. And the do not resuscitate, the DNR part, is that your heart stops beating or it's inadequate. And those are the two things that the doctor would probably put in his or her order. Do not intubate and do not resuscitate. Now, notably, that's signed by the patient, if they're capable, or the next of kin, or guardian, or, once again, the durable power of attorney for health care. And that's when you would have this attachment of the form that we've been talking about. Why would you ask a doctor to do a DNR? Yes, sir.
I was 90 years old. I had a series of events. I was laying in a bed in a nursing home.
I'm sorry, you said this is somebody, or you?
If I were 90 years old.
Okay, if.
I had good health, but I'm now laying in a bed in a nursing home, going through a series of strokes, heart attacks. They're recovering. But I'm saying, I'm done with this. That would be when I would call. It would have to have at that point, we'd have to have the facilities, faculties, to be able to make that decision and express it. But that's an example.
That's if you are capable of making that decision, but if you have a power of attorney, and if you are incapable of making that decision or expressing it, then you can rely, or you should rely on the agent to make that decision for you. And that's something that agent should be talking with you about, I should say, so that we have a clear understanding of what the patient would like. Now, under what circumstances, what would drive your interest to do a do not resuscitate? You said 90 years old, having poor health. I bring it down to 4 things. I'm sure there's more. There's expense involved. Let's face it, if I'm going to be putting my family through the expense, and perhaps the caregiving expense, or the insurance company even, of prolonging my life for 10 days, 20 days, whatever it is, pretty expensive. Second of all, some patients would say, I have a duty to get out of the way. I hesitate to say it like that, but I'm taking up space that other people can do. And to me, it seems like it's something that would be a good public thing to do. But beyond that, I think there's a great deal of patient fatigue at the end of life. They're just tired. That's been my experience anyway. And oftentimes they just say, to themselves at least, they're saying, I just want it to be over with. And not only is there patient fatigue, but there's also family fatigue. I mean, I've been around in families where they do the watch very carefully for the first week or so. And pretty soon, everybody's got to go back to work. Got your own family to take care of. And there's just a lot of tiresomeness, if that's a word, fatigue. Those seem like those are things that might drive me to say this. I don't know what other people might say.
There's the spiritual reasons as well.
Pardon me?
Spiritual reasons.
Okay, what about the spiritual reasoning?
Well, if you believe in heaven.
What's that?
If you believe in heaven, you might want to go there. So, but you'd ask about those addresses. That is Sainey's address and Brian's address.
There are differences of opinion, obviously based upon faith, and the sacredness of life within the Catholic tradition drives a lot of what the statutes say. When I did the revision of the statutory Anatomical Gift Act, which is giving away of organs, I met with the Catholic lobbyist, and he had 29 objections to the way things are written. And most of them were based on sacredness of life. And for example, who can order an organ gift when the patient is incapable of doing it? And some people would say one thing, and some people would say another, based upon a faith belief. I will say this, that by the end, the bill passed unanimously and without objection from the Catholic Church. You can find ways to work around a lot of these issues, but you have to be willing to work hard at it. It helps when there's not a lot of political skin in the game, and nobody's going to be trying to make a run for governor by being for or against something. I'm not saying that as anything relating to the current governor, but I'm just saying it's difficult in a political setting to find something that was as important to him and to me as we did, and yet find a way to do it, find a way to bring it. Other comments on why you might do a DNR? Not an NRD, but a DNR. Yes, ma'am.
On my last visit to my primary, I'm Medicare age, he brought up a subject that I don't know if it was initiated, if it was initiated by the federal government, state government, or what, because we're relatively new to Nebraska. So he asked me the question, have I thought about a DNR, into life issues? And so it was a general question. And so I said, well, framed it so that the quality of life issue would be my primary concern. Now, does he have the obligation to take it on to another level, incorporate this information on his patients per se? Does it have any legal holding at all, or is it just a conversation between doctor and patient?
I think at that point it's a conversation between doctor and patient. I think good doctors will discuss such things pretty openly with patients, I think. Pretty hard to find doctors having enough time of the day to sit down and say, hey, I want to talk with you about. But you can kind of force the issue and make sure that you do feel comfortable. It's then that person, you're the one that has to make the decision on the DNR. He has to order it, but you have to do the legwork to submit this. And in some circumstances, I'm not sure when this is, the doctor can order a do not resuscitate. And I can't see my nurse friend in the audience. Yes, sir. I don't know if there's anybody that would like to respond to that, whether the doctor will do a DNR on their own. My suspicion is in certain circumstances they may have an ethical obligation to at least ask it of a person, not of the patient, but of an agent. That would be an open question that we might leave for another time. Yes, sir.
Do these documents that you mentioned follow you to another state? So if I die in Colorado, does the Nebraska stuff follow me there?
Well, you ask a very good question, and that is the authority of a document executed in Nebraska to hold sway and be implemented in another jurisdiction. It really depends on what the issue is. I mean, you said these documents. Power of attorney, I feel comfortable if the drafting of the Nebraska power of attorney covers the same issues and covers the same spaces as the Colorado one would. Yes, I think it would be usable. That's again the advantage of a uniform act, where you have basically the same statutes being passed. That's unusual to have no changes in the statute, because there's always something you have to do in the statute to tailor it to Nebraska or to Colorado. There are some other things, though, that will not necessarily be used in another state. Your driver's license is used in another state. That's a good example of one that is useful there, can be exercised. But I think you'd have to look at the individual decision, the individual document that you want to have exercised. I am not going to tell you everything that you have to do. You have the right to have an attorney, and you probably have the obligation to also, if you're going to do these. I'm just doing this for purposes of highlighting to you some of the things you should be asking your attorney, or he or she should be asking you.
So we probably should carry it with us in our luggage.
Pardon me?
Carry the documents with us in our luggage.
Well, sometimes, yeah. Sometimes documents you should carry with you. I would carry a health care power of attorney if I was really careful. But that would require my older son then to be available too.
Yeah.
So there are things that you can do. At the thing the other night, the day here, there was an issue of getting his son that was in an accident in California and was taken to a hospital, I think, in Nevada, and how to get that person here for treatment. And how difficult it was for that person to get the person with the right legal support to get out of Nevada and get to Lincoln or Omaha. So the way to protect you, in some instances anyway, is to have that kind of a power of attorney that your son or daughter, whoever you have, that they have, because it's actually their power of attorney.
Thank you.
When I say that, I mean it's actually them whose authority is at issue.
One of the things my attorney advised me of is, and also my primary physician, was actually to file the power of attorney for health care with the hospital, with the providers, so that in fact they know that there's something out there and they have they have some opportunity to know who it is they need to maintain contact with or whatever.
You're absolutely right. One of the things you should do with your power of attorney, no doubt give it to the doctor, and the doctor should put it in your medical records. But it should also be given to the hospital, because hospital records are such that it'll be good for them to also, and anybody else that you might be implicated. There's no perfect way to do this, but that is what those kinds of records can be helpful.
One other item was when you're talking about the doctor making a decision. In some cases, it might be a committee. In other words, have more than one healthcare physician say that you're dead, or say that you can't sustain life. That way, it doesn't put the onus on one doctor.
I would assume that doctors are just like anybody else. They have differences of opinion, and one might say, well, I think that this person can be stabilized with an aggressive treatment plan that does this, and then you go to another one and say, well, I'm glad you think that way, but I don't think that's the way we can do it, and it's more likely than not that this person is terminally ill.
Another question I have. My wife and I both completed an advanced directive from Brian, LGH, 15 years ago. And one of the statements, it says, and it's about the living will section. Legal document that takes effect if you have a terminal illness or are in a persistent state, vegetative state, and cannot make your own medical decisions. My wife has been diagnosed with a terminal illness. And is this a valid document?
I think that what you're looking at is something similar to what I've got right here. Only this is Colorado's, but I'm sure that there's some similarity. A living will is sometimes called an advance directive, and an advance directive is sometimes called a living will. And in it, you say that if a physician says you have a terminal condition and you're unable to make any or communicate your decisions, then certain things that you are wanting to have happen should happen. And I've been going over these in a different source, different documents you can put it in. But one is to initiate whether you want life-sustaining procedures. Another is to initial whether you want artificial nutrition and hydration. And that is in a terminal condition, but sometimes you're in what's called a persistent vegetative state. That's what I think there was some reference to there. And I think that is just another word for you should be looking at life-sustaining procedures, or you should not look at it. I think what they're getting, I should look at the document, but it seems to me like some of these things that I'm saying are just repetition, but they're various ways of getting at the same question, whether or not you should have life-sustaining treatment. And I would be interested in seeing that, but my assumption, Brian, being the kind of facility that I think it is, that it would be authentic and useful.
And it also only required witnesses or a notary.
Notary public, yeah. Well, that's what I'm saying. You have to kind of look at it. That's what that directive says. Over here, if it was called the power of attorney, maybe it requires a notary public. So some of that is because these laws are passed over a period of years, 91, maybe 84, maybe something last year, 2025 or whatever. And they reflect what the going decision was on authentication. Well, I guess I'm done with powers of attorney, and timing. I'm over time. Okay, we got a decision to make. If anybody would like to have me stick around and talk about organ donation, I am more than willing to do that. I am very, very interested in that situation too. And I'll do that with you as long as you want to bear this. Other than that, I see it's 8:05. Do you want me to go like that, Carrie, or do you want to give it another 5 or 10 minutes? Oh, you got some questions.
Well, does anybody have any questions for Larry here before we wrap this up?
Nice to see you. We had a conversation last week. Any other questions? You got one?
Well, I just want to say let's thank Larry for being our speaker tonight. And I would like to thank you also for coming. I apologize to people online since we are working from a handout. If you would like to have the handout, please call the church office. And Stacy can help get a copy of the handout to you, probably by email. So just call the church office if you'd like that. And you might be saying to yourself, gosh, this is the first presentation I've come to. Well, this is our 6th presentation. They have all been recorded. So if you have interest, or you want to go back and hear what they said in March or January or whatever, it's on our YouTube channel. The church has a YouTube channel. You can always go back. We have people, and sometimes I know Larry and Pat's kids, some of them live elsewhere, so they get online and look, and your sister-in-law or whoever. So this presentation, thanks to Nancy, we have all those recorded. So we have one more presentation coming, same time, same channel, different date. It's not going to be in July, it's going to be at the end of June. We're going to meet on June 24th at 7 o'clock. And we have 2 sisters who are going to talk with us about handling their parents' estate. Now, you might be saying, well, that's, so what? Well, these sisters have kind of a unique situation. Their parents were members of this congregation, and they had moved to Lincoln upon retirement. And then one had become ill, passed away, and the other one died unexpectedly. And the sisters live 4 or 5 states away. So their dilemma is, they didn't grow up here, they don't know anybody, who do you talk to, who do you trust, and so forth. I think one of the things they're going to talk about is how important it is to have people in the church, or to actually have a church where their parents were members. So they've been able to handle their parents' estate well, I think. But, and we know it all can be a long and laborious process, but we would invite you to come and join us on June 24th. It's also a Tuesday night, 7 o'clock. Again, if you want to sit at home in your jammies and watch online, you can certainly do that. But we'd certainly like to have you come and join us on the 24th. That will be the end of our series for this year for Life and Legacy Planning. And I just want to thank you again for coming, and we'll have Larry talk here a little bit for those who would like to stay and talk about the anatomical laws and tissue and organ donation.